Welcome to the lecture series for Ethics in the Legal Environment. Let's begin with a case study. In 2003, the Supreme Court of Louisiana considered the attorney disciplinary matter of Lawrence Sledge, styled In re Sledge. The Louisiana Office of Disciplinary Counsel charged that Sledge, among other things, had operated a high-volume personal injury practice without properly supervising his staff of 4 or 5 paralegals and legal assistants. Sledge and his staff admitted that they used a rubber stamp with the respondent's signature to sign pleadings, and that at other times they would simply forge Sledge's signature. Routinely, the staff would meet with clients, draft demand letters, and negotiate settlements with insurance companies, all without Sledge ever meeting the client his firm was representing. One of his paralegals responded to the Office of Disciplinary Counsel that she had settled over 500 cases in 9 years without Sledge's involvement. Between 1996 and 1998, Sledge was absent from the office for months at a time, during which the staff continued to acquire clients and cases, prepare and file pleadings, and negotiate and settle claims. Sledge claimed that he was not aware of the extent to which his office was operating without his supervision until he noticed a decrease in his income in 1998. What do you think was the outcome for Sledge in this matter? Before we answer that question, let's review our lectures so far in this series on the unauthorized practice of law. So far, we have covered the foundations of the gatekeeping function of the Bar Association and addressed some of the specific activities covered by the broad meaning of the phrase, the practice of law. And we've covered the things that non-lawyers are prohibited from doing. In this final lecture in this unit, we'll cover the consequences of transgressing these rules, as well as a few miscellaneous topics relevant to this unit. First, let's talk about the consequences of the unauthorized practice of law. Mississippi Code Section 73-355 prohibits the unauthorized practice of law in this state, and Mississippi Code Section 97-2343 provides for criminal penalties for violating that provision. If you read that second statute, you'll find that the criminal penalties are not all that stiff. However, there are other penalties that professionals or those aspiring to be lawyers would find especially onerous. In Florida Bar v. Neiman, the Bar Association suggested the following guidelines for a paralegal who had exceeded his authority and essentially acted as a lawyer. They suggested that the paralegal was to have no direct contact with any client, opposing counsel, or third party. And he was instructed not to speak at settlement conferences, negotiations, or mediations, even with a lawyer present. He could not even prepare pleadings, motions, or other legal documents. These sanctions no doubt severely limited his market value as legal support staff, because he was restricted from doing many of the things that paralegals typically do. So what are the specific do's and don'ts for paralegals and their attorneys? First, it is important that you do clearly communicate the paralegal's role and limits. In fact, it probably protects both the lawyer and the paralegal if the paralegal's role and limits are specifically outlined in the legal services agreement signed by the attorney and the client. Documenting the expectations of the paralegal for the client prevents the client from incorrectly relying on the paralegal. Second, and related, it is important that the paralegal not inflate his role and decide that the client, quote, needs him to overstep. Staying within the clearly defined role of paralegal keeps him from engaging in the unauthorized practice of law. Third, do seek review from the attorney on all work. This is the paralegal's silver bullet. Since paralegals are permitted to do preparatory work under the supervision of licensed attorneys, submitting that preparatory work for review by the licensed attorney properly puts ultimate responsibility for the quality and accuracy of the work on the lawyer. Finally, and as a corollary to submitting work for review, don't sign correspondence with substantive legal analysis to the client or to the court or to other attorneys. When correspondence with substantive legal analysis goes out of the office, it must bear the licensed attorney's signature as evidence that he or she reviewed the work and attests to its accuracy and quality. Again, the lawyer is ultimately responsible for the work of the office, so any substantive legal analysis that leaves the office needs to bear the attorney's signature. That brings us to the rules of professional conduct. Mississippi Rule of Professional Conduct 5.3, which is substantially similar to the ABA's model rules, says that a lawyer having direct supervisory authority over a non-lawyer must make reasonable efforts to ensure that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. In other words, lawyers have a duty to supervise non-lawyers in the office and are accountable if non-lawyers in the office violate ethical rules. Lawyers are responsible for the actions of their support staff if the lawyer orders, has specific knowledge of, or ratifies the conduct of the paralegal. Lawyers cannot cover themselves by asking non-lawyers to behave in unethical ways. But lawyers are also responsible if they fail in their supervision of non-lawyers whom they employ or manage. This is sometimes called negligent supervision, meaning that if a non-lawyer in the office acts in an unprofessional or unethical way and the lawyer has failed to adequately supervise that individual, then the unprofessional conduct of the employee is imputed to the lawyer. Now, as paralegals, it is both humbling and a little bit of a burden to know that your boss is ultimately responsible for your conduct. Lawyers have an affirmative duty to supervise their subordinates, including their non-lawyer staff members, and the misconduct, whether intentional or not, of subordinates is imputed to the lawyer. A paralegal should remember that the supervising lawyer can be punished for the paralegal's mistakes. So to summarize this chapter, it is important that paralegals know the limits of their roles. It's also important to know these limits so that the paralegal avoids the pitfalls of holding herself out as a lawyer and become engaged in the unauthorized practice of law. People working in the legal environment need to know what constitutes the substantive practice of law. It's also important that paralegals know the limits of their professional authority because their bosses can be held liable for their mistakes. Since lawyers have ultimate responsibility for the work product of the office, it is imperative that paralegals make sure that their lawyers review the work before it leaves the office. So, what happened with Lawrence Sledge, the absent lawyer who failed to supervise his staff and then blamed the mistakes on them? Perhaps my phrasing suggests the answer. The Supreme Court of Louisiana opined, respondents' actions fell far below the conduct expected of lawyers in this state, and is an affront to those lawyers who strive to provide competent and ethical representation to their clients. The true extent of the harm visited by respondent upon his clients who were deprived of the benefit of a thoughtful, individualized, and professional legal analysis of their cases may never be known. Under these circumstances, we are firmly convinced we would be remiss in our constitutional duty to regulate the practice of law if we were to impose any sanction less than disbarment. This lecture concludes our unit on the unauthorized practice of law. Now that we have begun to define the roles and limitations of paralegals, we can build upon that foundation by examining some of the most important duties of lawyers: the duty of diligence and the duty of communication. Paralegals are indispensable to attorneys with large caseloads because they maintain the organization necessary to make sure that the lawyer is diligently working toward a conclusion for the client, as well as regularly communicating with the client, who serves as the principal of the representation and must be given the authority and ability to direct the goals of the representation. In the next unit, we will cover the duties of diligence, competence, and communication. Until next time.